Yeah, good weekend.
Well, welcome to the First District Court of Appeals. We have three cases on the docket this morning. And the first case that we're going to hear is case number C200139140 Junior Monroe versus Durrani et al. Um, Attorney for the appellant, good morning. If you
Good
can
morning,
identify.
Bob Winter for Mr. Monroe, and we're ready to proceed.
Thank you. And attorney for Durrani.
This is Jennifer Mitchell on behalf of the Christ Hospital. I don't represent Dr. Durrani, but I don't believe that he's involved in this particular appeal. I'm ready to proceed.
All right, thank you. Attorney Winter, would you like to reserve any time?
Sure, a couple minutes, Judge.
Okay.
One question, these three cases were briefed on a consolidated basis, and unless somebody objects, perhaps we could just do all three at once.
Yeah, absolutely.
Unless Ms. Mitchell has an objection.
No, that's quite, I think we've done this numerous times, and I think doing them all at once makes a lot of sense.
All right, Attorney Winter, whenever you're ready.
Good, yes, good. Good morning, judges, Ms. Mitchell. We're here on three issues preserved for appeal from the decisions of the Hamilton County Court of Common Pleas. One is whether the common law fraud claim presented here is a medical claim under 2305.113E3. The second is whether this court has inherent judicial power to recognize a fraud exception to the 4-year statute of repose at 2305.113C. And the third is whether negligent credentialing claim is a medical claim or is an independent non-medical claim. The court has ruled on several occasions on the first two issues, and I won't belabor them other than to say that yet we have three more appellants who Dr. Durrani treated at Christ Hospital, and Christ Hospital knew of Dr. Durrani's wrongful tendencies, reckless surgeries, and yet allowed them to proceed. That's fraud, and I would respectfully
Mr. Winter, let me ask you this. As you note, we have decided these issues multiple times, and you know, why is this appeal not frivolous at this point? I understand preserving issues for Supreme Court review, but you guys have had plenty of opportunity to get these issues up to the court, and you know, I didn't see anything new in this brief, and so was just curious as to your thoughts on that.
I indicated at page 1 of my brief, or my principal brief, that what the court's position is on these two issues, and I didn't want anybody to be under any delusion that we were trying to mislead the court. We were preserving them for review at the House Supreme Court.
Well, no, I understand that, but haven't you had that chance?
I'm sorry?
Haven't you already had the chance to have these issues reviewed by the Ohio Supreme Court?
They have turned them down on cross appeals from Dr. Durrani's, for example, in the Wilson Sand case. That was preserved on cross appeal, I believe, in the Andrew Carr and Sarah Jonas cases. Those were asked to be reviewed, and the Supreme Court decided not to turn us down. I'll also say that there's a case before the Supreme Court where we've asked them to take a look at these two issues again, and I believe it's Rachel Jones. Jones is the correct last name. So we're not done. yes, there's several. There's certainly more than 3 cases where the House Supreme Court has decided not to hear our pleas. Frivolous, no. I think they're brought in good faith. It's just we want to be heard and have these issues decided by the House Supreme Court.
No, I understand they're brought in good faith. It's not, but I mean, doing the same thing over and over again and expecting a different result is the definition of insanity. And we've ruled against you on these issues multiple times, and the Supreme Court hasn't taken it. At some point, I think you have to say it's time to move on.
Understand, we just respectfully contend that this is not a case where we.
You don't think we're there yet, huh?
That's correct. That's correct. But as you say, Judge Bergeron, you're right on the procedural postures of these matters. We're just trying to get the House Supreme Court to take the case, take these issues.
Understood. You can go on with your argument.
Okay, thank you. Negligent credentialing was recently decided with regard to the Evans versus Akron case in the Barbara Couch Consolidated Appeal. We've asked the court to reconsider that. We've also that decision on several grounds. We've also asked for en banc review, and we've also asked for the court to certify a conflict to the House Supreme Court resulting from its various cases here on negligent credentialing and the decisions by virtually all other district courts of appeal that have ruled either under the old statute or 2305.113E3 that negligent credentialing is an independent non-medical claim. And that was that rule was recognized quite clearly at paragraph 10 of the Akron Hospital case, Evans versus Akron Hospital. But just to point out a few points we'd ask you to consider. Browning was the lead case, stating that negligent credentialing is an independent non-medical claim. The Evans court recognized that, as well as the earlier case of Albion, in ruling in a case for negligent hiring. Second point is negligent credentialing is set forth under RC 2305.251, and it doesn't require the plaintiff to prove that a doctor, committed one instance of malpractice, but it had to prove, we have to prove continuing, ongoing non-conduct, wrongful conduct by the doctor to show that the credentialing and allowing him to or her to have staff privileges at a hospital was negligent. They kept on retaining an incompetent doctor. That's what negligent credentialing is about. It's not the hospital practicing medicine or giving care, treatment to a plaintiff. Hospitals don't practice medicine in Ohio. The doctors do. So we don't have a situation where the hospital is giving care, treatment, whatever the language is at 2305.113E3, the definition of medical credentialing. And based on that element of the definition of medical credentialing being absent, the rule of the estate of Stevick takes us out of a hospital having an independent claim asserted against it. That is an independent claim. Another point that I'd like for you to consider, please, is that the Schmitz versus NCAA case indicates that there are two triggering events for these two types of claims. The one is for negligent credentialing is the last wrongful act. The triggering event for negligent credentialing is when the patient becomes aware or should have become aware of the negligent. Excuse the noise. I mean, those are two different causes of action based on the triggering events, and they're negligent credentialing simply cannot be a medical claim. And the rest of my arguments are in the briefs, and I invite you to look at them. And I ask that if you disagree with the interpretation of Evans versus Akron Hospital and the other cases of the district courts of appeal outside the first district, I would ask you to please certify the issue to the Supreme Court and put me out of my misery. And I mean, the state deserves a uniform rule. If this honorable court is correct, we'll have a uniform rule. If the plaintiffs are correct, then we'll have a uniform rule, but at least we'll have a decision. And the citizens of Ohio are owed a decision. And thank you.
Thank you for your argument this morning. You still have your time reserved, of course.
Okay, thank you, Judge.
Attorney Mitchell?
Yes, Your Honor. On behalf of the Christ Hospital, I do believe that we have a uniform rule here in the state of Ohio on this issue. This court has repeatedly found that negligent credentialing is subsumed within the definition of medical claim for purposes of the statute of repose. Counsel, I believe, has argued that the elements that are necessary to prove a negligent credentialing claim, some that are found in 2305.251, somehow impact the analysis, but I don't believe that they do. That's a clear statute. If you got to the merits of a negligent credentialing claim, that's what would have to be proven. But that's putting the cart before the horse, so to speak, in that we're not even to that phase yet. This court is analyzing whether or not negligent credentialing falls within the definition of medical claim. It has found repeatedly, and as recently as the Couch decision, that it does. This court on March 12th, in issuing that Couch decision, put forth a very succinct and clear argument outlining its reasoning as to the Browning case. It's the progeny of the medical claim definition within RC 2305.113 and its predecessors, and address the Evans decision. I would just submit that.
Curious, Attorney Mitchell, I'm curious on something, because those provisions apply to employees. Was Dr. Girani an employee?
No, he was never an employee of the Christ Hospital, but since we're not really on the merits of the negligent credentialing claim, we haven't really gotten into that in any level of detail in any of the cases thus far. But he was not. He was on the staff, and the staff is credentialed just like the employees are credentialed. He was on the medical staff of the Christ Hospital for some period of time.
Thank you.
So I would just submit that this court should rule in these cases as it did in the Couch consolidated cases, and uphold the decision of the trial court on these issues. Thank you.
Thank you. Attorney Winter.
The last thing I would like to point out is that at one point, negligent credentialing was labeled as a medical claim. That holding, and as well as the other elements of the Tort Reform Act, were declared unconstitutional in Sheward case. the negligent credentialing, the medical claim statute was reenacted without negligent credentialing being labeled as a medical claim. And we've indicated under the Hodge case that if an unconstitutional statute or a statute that's been declared unconstitutional to be reenacted, they have to use the same language. They can't do a backdoor method of enlarging a statute. They have to use negligent credentialing. Otherwise, I would ask the court exercise its discretion and certify the question to the House Supreme Court at the appropriate time. And thank you, Your Honors, for your time.
Thank you both for your arguments this morning. We are taking the matter under submission. We will issue a timely decision, and have a wonderful afternoon.
Thank you, Your Honors.
Thank you, Your Honors.
Good morning.
Good morning.
Okay. Welcome to the First District Court of Appeals. We are now here on case number C200156162, Cyrus One LLC versus Great American Insurance Company. And counsel, I'd like to inform you that for today's arguments, on the camera, you'll be seeing Judge Bergeron and myself, Judge Zayas. You will not be seeing Judge Bach on the camera, but she is involved in participating in the case, and has, prepared and will be part of the decision, of course. So, attorney for the appellant, can you please identify yourself and readiness to proceed?
Good morning, Your Honor. My name is Joe Nealon. I represent Great American Insurance Company in this case, and I would like to, with the court's permission, reserve 4 minutes for a rebuttal.
Of course. And attorney for the appellee? You're
You're muted.
You're muted.
Pardon me. I
No
hope that's the
worries.
last time I make that error.
No worries.
My name is Ted Martin. I represent the appellee cross appellant, Cincinnati Bell, in Cyrus One.
Okay. And would you also like to reserve time?
I would, thank you, for 3 minutes.
For 3 minutes, okay. Attorney Nealon, whenever you're ready.
Thank you, Your Honor. There is no claim in this case that Dennis Scheib stole any money directly from Cyrus One. The claim is that Mr. Scheib convinced 9 or more subcontractors and vendors to steal $5,654,560 from Cyrus One and kick it back to himself. This court should reverse the judgment of the trial court for at least 4 reasons. First, there is no evidence that $3,235,954 of that 5.6 I just mentioned a moment ago came from Cyrus One. In fact, there is no evidence in the record where it came from. Second, there is no evidence that the 5.6 million and change was stolen from Cyrus One. Plaintiffs offered no proof other than one invoice for $170,000 that the money that went into Scheib's pocket first came out of Cyrus One's pocket. Third, Cyrus One discovered the claim on which plaintiffs are suing on or before August 4, 2011. So the 2-year contractual period of limitations, as extended by Great American in this matter, had already expired.
Therein you're relying on an email exchange that had taken place, is that right?
I'm relying on the email exchange plus the documents the next day. I can address the court that issue right now. I'm relying on the email, number one, which was exhibit number 30 in the exhibits we presented to the court, and I'm relying specifically on the language.
Well,
in that
I mean, looking at that history, clearly the company was trying to figure out what was happening, which is a prudent measure to take. And this is very sensitive. Like, you don't want to accuse someone of theft without being pretty sure that that's actually occurred. And that email to me doesn't seem to be the silver bullet that says, aha, they had complete knowledge as of the date of this email.
Well, Your Honor, with all due respect, they don't need complete knowledge. They have to have facts which would lead a reasonable person to conclude that a loss had or would occur. And they had the email which says, we have begun to identify this scenario during his employment with Cyrus One. As I know the court is aware, in the lower court's decision, which is the focus, the trial court specifically found at page 5 of his opinion, quote, on August 4th, 2011, KPMG reported they found no evidence that Scheib had any improper transactions during his employment with Cyrus One. That is the trial court's finding. That is directly contradicted by the email, which says that, yes, the transaction presented by the email related actually to a Cyrus One project earlier that same year, but it says we've begun to identify the same scenario during his employment with Cyrus One. In addition, we have the dispositive admission by Mr. Elma on the stand, which we cite in our brief, in which he understood that's what the email was saying.
Well, but if the email, the email doesn't say, here is the scheme, here are the damages, here's what we've discovered. And this isn't just somebody taking a little money out of the till that we can, figure out that, oh, they took that. I mean, this is very complicated. In fact, your first argument is the court erred on its calculation of damages. So I think there's a disconnect between the precision that you want on damages and your interpretation of this email.
Well, again, I'm going to respectfully disagree with the court. I think all the insured has to know the scheme which they're relying upon, whether it's stealing $100 or $100 million, is that Scheib was working for vendors during the period of time he was supposed to be working for Cyrus One, and he was getting paid by those vendors. So what this email did is it showed Cyrus One a specific example of when that occurring just earlier that same year. And then it said, we've identified this same scenario during his employment with Cyrus One. The key, at least,
understood, Attorney Leland. I want to go back to my question because you began to answer it, and you said that you were relying on the email and you were also relying on other documents.
Right, I'm relying on email. Yes,
so
yes.
So what were those other documents?
Well, the other documents are exhibit number 31, which is an August 5th memo from Paul Marvin to the people running Cyrus One at that time, as well as to Mr. Elma, in which they removed Scheib from responsibility for the projects. So the day after this email that I'm relying upon, there is an internal email in which they removed Scheib from the project. Plus, the Cyrus One, in its discovery responses, exhibit number 64, specifically highlights that on August 5th, they decided to cut Scheib out, and they took control of the projects. And that's on page 7 of the admission of the discovery responses, which was admitted at the trial. So we have if you would, we have not just the August 4th email. We have we have the email the next day. We have the admission by Cyrus One in their discovery responses, and we have the admission by Mr. Elma on the stand as that he understood what the email meant. Remember, it's not as if Cyrus One came to this unaware of an issue. They had already gone to the postal inspector.
But
they had already.
However, our standard of review is manifest weight.
And I,
So the determination by the trial court, what we have to look at whether it's supported by competent, credible evidence, right?
yes, you do, Your Honor. And that's why I started.
So then it isn't so much whether we would have found it differently, it's whether the evidence is supporting this determination that was made by the trial court.
Right, and that's why I mentioned, highlighted, I thought, maybe not very well, the fact that the trial judge specifically found that there was no evidence. So when I've given you all this evidence, it was clearly against the manifest weight. He was wrong. I don't know if he didn't read the entire email. I don't, obviously I can't speculate on what the trial judge did, but.
Well, so let me make sure I understand. So your theory is that as long as the company had notice of a scheme of some sort, that triggered the clock ticking for purposes of this limitations provision. In other words, like they don't have to know the amount of damages or anything about the damages. They just have to know there's a scheme.
Right, and the discovery provision in the bond is specific about that. It says you don't have to know the details or the amount of the damages. It's very specific in that regard. And the issue is, did the trial court, if the trial court didn't say, well, I've looked at this and there's some discrepancy. He said there was no evidence. I think I pointed to you to the email as being evidence. The email the next day is being evidence. The admission by the witness on the stand. I think all those issues are dispositive. I think
your position is that the reason that it should be reversed on the manifest weight is because there was a finding of fact that the trial court made the determination on that it's not supported by the record.
I didn't say it that well, but exactly.
Okay.
And then let me the last point, obviously.
Going back to knowledge, knowledge is the existence of such facts as would justify a careful and prudent person in charging another with fraud or dishonesty. So, it's basically whether the facts, all of the facts, and I'm going to just talk about the facts that you're relying on in your argument, the documents that came after the email itself, whether that rose to the level of justifying a careful and prudent person in charging with fraud or dishonesty.
Well, yes, and they removed him from the projects. He resigned a few days later, or he gave notice of his intent to resign a few days later. And so I think the fact pattern there is fairly clear. And obviously, Your Honor, I also think that putting aside the documents, if the witness gets on the stand and says to the trier of fact, I knew this is what it meant, and that's what he said. And that when the case was before Judge Winkler, we didn't have that admission. Now we have it, and I think it's clear. So let me. The last point that I was going to raise is the failure to cooperate and the fact that the tapes were destroyed or lost, and they could have been dispositive. Now, I've taken a great deal of my time, so let me just highlight those other three arguments, and if the court has any questions about them. The first one is simply the fact that $3.2 million in change is missing is a question of math. If you look at their second exhibit, I don't remember any
just
time.
So you know, Attorney Nolan, I recognize that you have 1 minute left, and I also recognize that this case has a lot of complex issues. If you're both in agreement, I'm happy to give both of you an additional 3 minutes.
I'm happy to give Mr. Martin an additional 3 minutes.
Okay.
I won't. I may not need my time. At least I hope I don't.
Okay.
It'll depend on your questions. The first argument, the fact that there's 3.2 million in change, which is missing, that's simply a question of math. If you look at exhibit number 2, plaintiff's exhibit number 2, which we included, I don't remember ever doing that in a brief. You add up the math, and 3.2 is unaccounted for, and it's laid out on our brief on page 14. It's 2,418,000. It's rounded to 2,420,000 is all they could trace. And the basic principle of in this case is that it has to be the
but he said, Bailey testified that here's how the scheme works. Here's how parties are damaged by kickbacks. and then here are specific examples that I have. And I don't have all of the examples, but I do have his tax return, and therefore that is the appropriate benchmark for awarding damages. Now, again, like, I don't know whether I would have agreed with that or not as trial judge, but we are here on manifest weight. And I understand your point that, well, they didn't give the precise documentation for the other 3 million, but isn't that testimony by an expert sufficient, just like it would be for a contractual case where you say, well, I'm projecting lost profits and here's my projection?
No. First, Your Honor, we're not on manifest weight with respect to the calculation, because the trial court said they agreed with Judge Winkler, but the trial judge did not apply Judge Winkler's standard. Judge Winkler could not have been clear, and he gave a specific example. He said, with respect to CIS, one of the vendors at issue, he said the fact that CIS gave money to Shive doesn't mean they passed on that money, that cost of that money, in inflated invoices or other documents. You had to prove it. That's what Judge Winkler found the standard of law was. The trial judge said he was following that standard, but didn't do it. And if the court's looking for where that appeared in Judge Winkler's opinion, that appears on page 17 of his opinion. He said, quote, although Shive received these, quote, kickbacks from CIS, it does not necessarily mean that CIS passed those costs on to CyrusOne through inflated bids. So I think that you have to look at this de novo in terms of the math, because the trial court did not apply the correct standard that Judge Winkler had laid out. He didn't show that the money first came from Shive. You can't speculate. You're giving $3.2 million to CyrusOne when they can't prove that it came from CyrusOne in the first instance. And this should have been the easiest thing. CyrusOne knows every check that it wrote on every one of these 21 projects. It could have traced the money from its coffers to the vendors to Shive. It did it for 2.4 million, but it couldn't do it for the 3.2 and change. And that's why you should reverse. And then it goes to the second issue. You have to show it came out of CyrusOne's pocket. That's the standard. The trial court said, I'm following Judge Winkler. His opinion, it says I'm following it, but he doesn't adopt it. He doesn't follow through on it. He doesn't show. There was only, the court said there are examples. There was only one invoice that was presented in testimony, $170,000, where they tried to show that there was an inflated invoice. They didn't even prove that one. They never proved that CyrusOne actually paid it. But putting aside that doesn't even get to the $1 million deductible. You have to show that these inflated costs, whether it's 2.4 or 5.6, were actually were actually paid by CyrusOne. If Shive convinced a vendor to give him money, that's not Great American's problem unless that vendor stole from CyrusOne in the first instance. And that wasn't proven in this case. The last point about the tapes, I think it's incredulous that we have a situation where CyrusOne, I mean, the court asked the questions about what they knew. CyrusOne put a secret recording in his office, taped him for months, and never disclosed those tapes to Great American. They could have been dispositive. They could have shown discovery at an earlier point. They could have shown theft at an earlier point. They could have been dispositive of the issues in the case, and we never got to hear them. And it was years into the case and that we even learned of their existence. The court should have, the lower court should have let us present that defense and make a judgment. All the inferences should have gone in our favor, and we should have had an opportunity to present that defense. That's if I was if I was seated before you this morning arguing about 6 months of documents on this claim that Great American had lost, I think CyrusOne would have a very different view. The bottom line is Judge Winkler got it right.
Thank you for your argument. Thank you for your argument.
Thank you very much.
You still have your 4 minutes reserved.
Thank you.
Attorney Martin, so now that we've adjusted things, you have 3 minutes that are reserved, and you have 15 minutes for your initial argument, okay? Oh, again, All right. Oh,
You
you're
turned
off
it-
again. You turned it on for a second and then it went off
I'm sorry, can you hear me now?
perfectly.
I apologize.
No worries. No worries.
Thank you.
Mr. Martin, could I prompt you with Mr. Nielsen's question about, or point about, you all had all the documentation. You knew who your vendors were. Why didn't you present that evidence at trial to substantiate the full 5.6?
Well, thank you. That would assume that every time you're taking a bribe, you make a note that says, hey, we're taking a bribe. We know that people who are involved in collusion like this, Supreme Court tells us, Justice Harlan, that people tend not to document when they're taking bribes. They don't write receipts. This is for the bribe. That is and the degree of certainty necessary is the amount which the case permits. And in a case that we've cited in another case involving a bribe, the court said, well, what proof of the amount of damages does this type of case admit? And it said, well, you have to, and that the bribes are a good measure. Does that answer the question?
Well, I guess maybe the question should be better phrased, which is, you had the evidence related to the 2 point whatever figure. How did you find that, but not the evidence on the 3 million?
Well, we were able to identify some through subpoenaing bank records. So we knew we had 2.4 through bank records of specific payments. But we know where we do know where the 3.4 comes from. There's no question that it comes from CyrusOne vendors. How do we know that? We know that because specifically, Shive was asked the question, did you receive any money from any contractors or vendors or subcontractors that were not contractors, subcontractors, or vendors of CyrusOne? So he's saying all the money, the 5.6, is coming from CyrusOne vendors. Sometimes you don't want to ask the next question, but I did. Do you have any documents whatsoever that show any work that you did for any contractor, subcontractor, or vendor that was not related to CyrusOne? No. Then we have another substantiation for the 3.2. What does he say he was doing for this 3.2? He says, well, I was consulting and selling my time at $250 an hour. You can't get there. That is, if you need 4,000 hours at $250 an hour to get to $1 million. You'd need close to 13,000 just to get to the 3.2. And he's working full-time in 3 cities, overseeing $100 million in construction, working 24, he said when he took the job, working available 24/7. So we know he's doing, that's his testimony. We know it's not true. That's not, that he's not selling his time. And he has no time records. He has no time records that justify that. So we know that the 3.2 also comes from, is a bribe. With that information, where it's coming from CyrusOne, I think then, and even Mr. Nealon was asking closing, are you claiming that Shive did not take payoffs and kickbacks? I'm not claiming that. He's claiming, well, you haven't showed it, it inflates it. So we know that what he's saying isn't true. We know that he's taking bribes, and we know all the money is coming from CyrusOne's contractors. That is an extraordinary.
Well, but then to get to the next step to show that your client was actually damaged by that. I mean, you could certainly imagine a kickback scenario in which the vendor agrees to take a lower profit margin to get the work. So in essence, splitting the difference with the employee, which would then not create dollar for dollar damage to the company. So I guess, I mean, I guess your answer is Bailey. Bailey connects those dots. Is that it?
It is, Your Honor, because he is an expert. They've stipulated to his qualifications. He was completely, there was no rebuttal expert. There was really no cross-examination on this. And what he really showed, testifying as someone who understands the economics, he said, maybe an example helps. And he testified theoretically on this in terms of a hypothetical, as opposed to in this case. Let's assume the amount that a company pays is $125 for a widget. And that has two components, the bribe of $25 or kickback of $25 and the amount that the vendor takes, $100. The $100 the vendor takes is the market value. It is what he is a willing seller is willing to enter into the deal for. The $25 is the bribe. That inflates it. Now, a willing buyer and a willing seller, what would an honest employee do? An honest employee would drive the price down to the $100. That's what the vendor is willing to enter the deal for, right? Instead, he doesn't do that. He takes that $25 and he puts it in his pocket. And now, Mr. Nealon said we have to prove theft. That's not what the policy says. It shows loss. Later policies, as the courts have talked about in some of the other cases, have shown that theft is a higher standard. We have to show loss. And here we have inflated invoices. In fact, what the
saying is that Judge Winkler had set out a standard that was not followed.
His standard was we had to show that we paid inflated prices. And Bailey testified as an expert that the amount of the inflation and the depletion of funds was $5.6 million. So he showed this on that this is a matter of economics. Now, certainly that is not.
He also argued that Judge Winkler had set forth that basically that there wasn't any evidence that it came out of Cyrus One's pocket.
I don't think that's what Judge Winkler said. In fact, binding is the arbitration award in this case, which found that he profited in the amount of $5.6 million. And
I got confused by the arbitration award because Great American wasn't a party to that. You can't use that to stop them in any way.
Well, that was never appealed, Your Honor. The binding nature of the arbitration award was never appealed. It's not as an assignment.
Well, no. I get it that it's binding between the parties to the arbitration, but I don't understand how you can use an arbitration decision that a party was not a party to against that party.
Well, Judge, that was a finding by the court. It was based on that they were in privity. Under the notions of privity, they had the opportunity to attend and participate and they did not do so. They were invited to attend and did not. And at the end of the day, they have not appealed that decision.
What do you mean invited? I mean, were they a party? I don't understand how someone shows up for arbitration without being a party.
Well, they were, Cyrus One invited the Great American to participate. They were on notice of the claim and they said, do you want to come and participate? They said no. They didn't show up. And again, they haven't appealed that aspect of the decision. I mean, to the extent that you disagree, but it has been waived. It hasn't been appealed. And it was never an assignment of error. At the end of the day, though, we don't need that because what we have is $5.6 million. We have documentation of where the 2.4 comes from. The 3.2, his explanation doesn't make sense. We know it's not true. And so I think it's clear.
Mr. Martin, could you shift to the second assignment of error and the timeliness and maybe start by responding to Mr. Nealon's point that, you had inquiry notice, or I forget his phraseology, but you knew enough that there was a loss or a suspected loss at that time, and that was enough to trigger the clock running.
Well, first of all, Mr. Elma said, I didn't get facts on August 4th. He never agreed to that. What he said is, yes, when you look at this email, what he said is when the writer, Mr. O'Connell, says that they've begun to identify the scenario during his employment with Cyrus One among the documents, and they're analyzing it, and they're focused on finding this. What did they present him with? They presented him
I
with
think they're
one.
also focused, their argument is focused on the sentence that precedes that. It's, you know, here are examples of what we have pulled together related to subcontracting and payments, which go back to Dennis's business, Data Center Management Services, DMS. We believe that this, my printout is terrible, may be the principal scheme. So it's by, you know, it's basically by inference saying that there's a scheme with regard to DMS, and we have begun to identify this scenario during his employment with Cyrus One.
Begun. It may be, we believe this may be, and may is not enough, and we've begun to identify it.
So are you
There wasn't
saying that
any
the
testimony.
identification of DMS is not consequential?
Excuse me?
Are you saying that the identification of the scheme within, as it relates to DMS, is not consequential to the scheme as it relates to a scheme as it relates to Cyrus One?
No, Your Honor, that was before he became employed by Cyrus One. They have to show that it is a covered loss. What he did before he came to Cyrus One is not a covered loss. It can't be covered. So that was before he was an employee. It must be as a result of dishonest employee. What he did sometime else. And this is the first time there's any evidence of money that he was getting. First time. And look what they did before that. They had Premier, which had done accounting. Nothing. Okay. You can't support it. They had KPMG been looking for months for anything. And what do they give him on August 4th? They give him one document that shows when he isn't employed yet. And they're saying, well, we've begun to do it, but they haven't yet.
Well, but what precipitated the request to the postmaster?
Well, I think that first they were trying to get help in the investigation part. They were hoping that the federal government would help and the post office would help. And the post office said no. But I think it is prudent to reach out to see if you can get government investigators to help. And that's what they did. And now, again, take into account this.
Attorney Nealon, I apologize. Attorney Nealon also referred to Exhibit 64, which is dated August 5th. And I think there was another exhibit that then took the employee out of the position or out of the responsibilities that he had.
Well, he didn't have the same, he was still involved, but he didn't have decision-making. That had begun earlier. The attached to that document, again, is a email from earlier in July by somebody else who Mr. Elma said had never even talked about this. Now, again, think of this as well. He gets that email on August 4th at 4:30. And yet he has to be able to appreciate the risk. And then so at that point in time, and the deadline is, that's a Thursday, by Sunday night, he has to figure out all the significance of this.
No, I thought it was just you had 2 years to file the claim.
Well, but the deadline was going to be on Sunday. The deadline, they have to show that we discovered the loss before Sunday midnight. So he gets this email on Thursday night at 4:30, and he has to be able to appreciate it. And again, take into account everything, it looks crystal clear in retrospect, right? But would you charge someone? Think of this also. What would a reasonable person do before going forward? They would at least ask the employee. Before you charge them, wouldn't you say, give me an explanation? That's what they did do. I don't want to reduce this, but I have unless I can also cover it in my reply, but there are issues here about the.
There's still one more.
Sure.
There's one more argument with regard to timeliness that I'd like for you to address.
Sure.
And that is that the trial court basically erred because of the statement that there was no evidence. So that statement, that the trial court's determination was based on something that was not reflected in the record. That there was
I actually
no
think it
evidence.
absolutely reflects it. There is no evidence here. Again, Mr. O'Connell said the same thing. Mr. O'Connell said, I didn't have anything. This was all, I didn't have any evidence yet. They had begun to do it. And I think this reading of the email is, show me a fact. Again, this is based on facts. Show me a fact that shows that there is even any dishonesty. And the result was, well, no, they gave a document that is outside the time period. They said they've begun to do it, but they didn't yet have it. And I think he's correct. And then the judge also said, and plus that would only be suspicion. You'd have to talk to employees, and that's what they did. I think that is
according to your view of the world, when do you think the clock started ticking?
After they spoke to the employee, they spoke to Scheib on 2 weeks later on the 24th and said, where's the source of all your wealth? And he said, I'm not going to tell you. Then they talked to vendors and contractors, and they did this methodically. They did it. They had to be discreet. When you do these exams, you have to do them discreetly. These investigations. They asked Scheib, and then they talked to contractors and vendors. And contractors and vendors then began to explain what had happened.
Thank you. You have 1 minute left.
With respect to the issue on the tapes, it's sheer speculation that they're suggesting that she lied, and there's no evidence of that. The woman who had these tapes said, you know what, we had this recorder in there, and I listened to it, and there was like, you couldn't understand. It was very, very difficult to understand anything. And I listened to them, and there was nothing on there that in any way suggested that there was anything that was not in his interest. And they say now Great American argues, well, the tapes could have been enhanced. Well, they never argued that below. And what they say now is, so the fact here is the person who listened to the tape said there's nothing on the tapes. That it was very, very difficult. He didn't say anything. Now, remember, this is at a time when they're really trying to focus.
Was there any claim for spoliation on that?
Well, there wasn't, and the court said that denied the motion. Okay. And they did not appeal that motion.
Thank you, Attorney Martin. Attorney Nealons, you have 4 minutes in rebuttal.
All right, Your Honor, just a couple of points, if I may. Number one, Mr. Martin misquoted Mr. Scheib's testimony. I'm sure it was unintentional, but we set it forth on our brief, on our reply brief on pages 8 and 9. He seemed to be suggesting that Scheib admitted all this $5.6 million came from CyrusOne. He said the exact opposite. In fact, he was asked the question. So let's look at the bottom where it says the gross amount, all these numbers, 5,654,560. Do you see that? Answer, I do. Question, is that amount solely and exclusively connected to or related to CyrusOne? Answer, no. He went on to explain, and he gave them a list of their other customers he had. So the point that Mr. Martin was making is just simply wrong. Scheib never admitted that fact, and that's an important consideration. The second point, Mr. Martin kept saying that the arbitration was binding. It was not binding. Great American was invited to come and sit in the audience. It was not a party and could not have participated. In fact, Judge Winkler, in his opinion, found that Great American didn't even get the documents relating to this claim until after the arbitration. And that appears at page 7 of his opinion. And then Judge Winkler went on to say specifically that the 5.6 was not binding on Great American. That appears at the bottom of page 14 of his opinion, where CyrusOne argues that its loss is the total amount. This is exactly their argument. CyrusOne argues that its loss is at least the amount of the bribe Scheib received, which is 5.6 million and change minus the deductible. And the court's quote, the court agrees with Great American that the damage portion of the arbitration opinion does not preclude Great American from litigating whether or not CyrusOne established a covered loss. So that was specifically addressed by Judge Winkler, and he got it right. I don't know what Mr. Martin thinks we could have appealed. We weren't party to the arbitration, and we got the decision from Judge Winkler that we wanted in that regard. So it was not binding. Then he went on to discuss the email and talked about they only had until Sunday to appreciate the significance. I don't know what he is arguing. They had, as the court indicated, 2 years from August 4th to sue. And Great American actually extended that, but they had plenty of time to appreciate everything. The next
according, as I understand your argument, it would have been 2 years from August 5th.
Right. It would have been 2 years from August 5th. Now, then we entered a tolling agreement as well. So they had.
August 5th would have been a Friday.
Right. But
I understood.
I think that's what he was saying. But actually, it's August 8th is the key date because we extended it. They had until August 8th, 2 years from that date in which to sue. So even if you take his scenario, they had to decide by Sunday night. They still had 2 years from Monday morning to make a decision, and that's more than enough time. The court asked a question about the 2.4 million, and I just want to be clear. Great American is not saying that the 2.4, which they were able to trace, that's simply money. That's the first step. They could say that some money, 2.4 million, went from Cyrus One to vendors to Shive. They can't do that with the other money. It's not a question of a notation on a check or on an invoice. It's simply tracking the money. Attorney
Leland, you have 30 seconds.
Then I'm going to stop. I appreciate the court's time this morning. I wish we were together to do this, but so be it. Thank you very much.
This is the next best thing right now.
Exactly, Your Honor. Thank you.
Attorney Martin.
Thank you. The testimony I cited was on page 290 of Shive's deposition, where he said that it all came from Cyrus One. And so there's a question about it. And now in terms of how long they had to act, the question is, when did they discover the loss? And that's why the date's so important. Not when did they sue, when did they discover the loss? They say it was, well, the email that comes in on the 4th. And what do we know is that that's a Thursday. So they have to show not only that he appreciated that they had facts that would cause a reasonable person to know to charge someone for fraud, and that he had to come to that conclusion before August 8th, which is a Sunday night, his 1 day. And then he has to put it also in the context of coverage, right? Is this a covered loss, which means, is it money out of our pocket? And they had done all sorts of investigation. Let me just briefly talk about, because I know it's unusual. We asked for summary judgment on the issue of bad faith. And here, there is extraordinary evidence that Great American admitted that you should not have that, you need to do an investigation. They didn't. They have the Save Me email. In this case, the person who made the decision to deny the claim did not know the facts and couldn't know the facts because he didn't investigate it. And he relied on a claim file that was devoid of information. And the amount of information he didn't know is listed. But it is, it's inconsistent with Zappa, which requires an affirmative duty to do an investigation and to pursue information. And that wasn't done here. And that's bad faith. For claims to be decided by by the person who doesn't know the facts, that is inconsistent with any notion of good faith. They say that it has to be based on a reasonable investigation. Get the facts. How can that matter when the person who makes the decision doesn't know the facts? And we've laid that out in our briefs, but that is this unusual? And in addition to that, there is a email on the day after the notice comes in 1 day, there is an email where the adjuster saying, save me, can't afford another loss. The next day that they misstate the policy and they say that's bad faith. And they misapply the application of the law to the policy, which they also say is bad faith. And they ignore one of their own precedents. Time and again, they've shown that they were acting in an arbitrary and capricious manner. But for summary judgment on our favor on that issue, the fact that the decision maker didn't do the investigation and relied on a claim file, which is only randomly kept, and doesn't even have the project files, doesn't have the accountants, the financial experts analysis, that's bad faith. You have to base it on facts. And if you don't know the facts, that's bad faith.
Thank you
Any other
both for your
questions?
arguments this morning. Thank you
Thank
both. We will take the matter under submission and issue you a timely decision. And I wish you both a wonderful afternoon.
Thank
Thank
you, Your
you.
Honor.
Okay.
All right, good morning.
Morning.
We're here on our third and final case number C200158 and 159, State of Ohio versus Kimberly Kristen. I'd like to inform both counsel that today's argument will include Judge Bergeron and myself, Judge Zayas. Judge Bach will be reviewing the arguments and will be, and has obviously prepared and will be reviewing the arguments and will also be part of the decision. So on that, if attorney for the appellant for Kimberly Kristen can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Joe Surrey on behalf of Ms. Christian. I am ready to proceed.
Good morning, Attorney Surrey, and attorney for State of Ohio.
Good morning, Your Honors. John Vogt on behalf of the state, ready to proceed.
Good morning, Attorney Vogt. Attorney, is it Surrey?
Yes, ma'am.
Okay, thank you. Attorney Surrey, would you like to reserve time?
If I could reserve 4 minutes, please.
4 minutes. All right. Whenever you're ready, you can go ahead.
Thank you, Your Honors, counsel. This is a case involving a request for an expungement of what would normally be a non-expungible charge. Just by way of a little bit of background, Ms. Christian was charged with OVI and a traffic light violation. Through discovery and negotiations, the city of Cincinnati offered to amend the OVI charge to a reckless operation under the city code and dismiss the second OVI and the traffic light violation. Ms. Christian was sentenced. This is normally called a wet reckless. It's technically not anything called a wet reckless, but it's the understanding between the parties that it's an OVI that's amended down to a reckless operation, and then the individual does penalties that are similar to the OVI.
And that just blows my mind that it's so common that there is a name for it. I mean, that is troubling to me. And I know that's not any part of your argument, but sorry.
Understood, Your Honor. Yes, it's an extraordinarily common plea agreement under certain circumstances. Generally speaking, it has to be a first offender, not a serious offense in terms of the degree of OVI. But in this particular case, that's what happened. Ms. Christian completed her sentence as required, waited the requisite amount of time for an expungement. In this case, a misdemeanor takes 1 year after the sentence is complete. It was approximately 1.5 years before she filed for the expungement. So in looking at, and I use the word expungement interchangeably with sealing. I think the technical word is sealing of the record, but we generally call it an expungement.
Right, I noticed that, and I don't know that I can say the statute uses it interchangeably, but certainly the statute's use of expungement and sealing and so on, particularly when you get to 2953.61,
Yes,
makes it quite interesting.
Yes, it does. So in this particular situation, I think there's 4 statutes that we need to look at to kind of walk through the eligibility and then whether or not the court would have the authority to expunge or seal Ms. Christian's record of conviction. So the first one will be 2953.32, which is the statute dealing with expungement of a conviction. In that particular statute, you have to wait 1 year if it's a misdemeanor conviction, and then are you an eligible offender? So moving on to 2953.31, we have to determine if the individual, in this case, Ms. Christian, is eligible to have that expunged in the sense that what does her record look like? So there's no dispute on that, right? No dispute, Your Honors. This is a first offense. Waited plenty of time. No issue on either of those, and I don't believe the state is arguing that either. Now the question becomes, and these are the two statutes that are at the crux of this, can the offense be sealed? Legally, can it be sealed? We have to look at 2953-36A2 and 2953-61B1. Under 2953-36A2, the general rule here is that convictions under Chapter 4511 or under Section 40, Chapter 4511, i.e. the traffic code, are not eligible for expungement. So for example, if I were to get a speeding ticket and I pay it out, I am not eligible to have that expunged. However, the last sentence of that section says, except as otherwise provided in Section 2953-61 of the revised code. So the normal rule would be traffic violations are not expungible, traffic convictions are not expungible, except if the exception applies. And in this case, it does. So looking at the exception, we have to see if the three prongs of that exception are met. In this case, they are. So the first prong of the analysis is determined if there were two or more offenses.
You're referring to it as traffic convictions. It's really about the 4511, isn't it?
It is, yes. So in this particular case, it was actually a conviction under the City of Cincinnati Municipal Code.
Right. It would be the equivalent of.
It is,
right.
Yes, ma'am. And the section of 2953-36A2 specifically references a substantially similar municipal ordinance, which I think the state and I are in agreement with that it does. So normally that would not be eligible for expungement or to be sealed. But in this particular case, an exception applies. So we have to look at the first prong. If two or more offenses were the result of or in connection with the same act. So in this case, there's two or more offenses. There's the OVI and the traffic light violation. If one and only one of those charges is a conviction under any section of Chapter 4511 or substantially similar municipal ordinance, other than OVI, other than physical control. So if this were a conviction of physical control or OVI, the analysis is over. In this particular case, one and only one conviction occurred for reckless operation under the municipal ordinance. And then the third prong requires a determination.
Which is 4511.20.
Correct. Yes, that would be
the ORC. If
yes,
you
ma'am.
take the substantially similar of the wet reckless.
Yes, exactly. And then the third prong of the statute requires us to determine if the records pertaining to all the other charges, that is to say the charges other than the reckless operation, would be eligible for sealing under 2953-52, which is the dismissal statute or the acquittal statute. So in this particular case, because the other two charges were dismissed, we meet those three-prong requirements of that exception of 2953-61B1. It's admittedly a very convoluted path that we have to follow, but looking at each section in the plain language of the statute makes her eligible for the expungement.
So your argument is basically based on plain language interpretation of the two governing statutes that would be the equivalent of the municipal ordinance. The state, in their brief, one of the things that they raise is that looking at the B1 section of 2953.61, that it governs when there's multiple offenses. And so one of the arguments is like, well, if that doesn't make sense, your interpretation, because if it was only one offense, then there would be a different outcome.
Yes, and so I think the state makes two arguments. One is that 2953-61B1 provides a limited exception to the sealing of records of non-conviction. And then the second argument they make is sort of that unequal access that, well,
right.
If there was
so
only
I'm only asking up with regard to that second argument right now of how you
Sure.
would respond to that.
So it at first blush, it does seem confusing on that, but there are multiple circumstances where that would apply appropriately. And for example, if one were charged with OVI and a turn signal violation, and you went to trial on that case, and one was acquitted of the OVI, but convicted of the turn signal violation, that person would, under the state's position, be ineligible to have the OVI acquittal expunged because there is a traffic conviction. The statute specifically permits that. In the normal routine of things, granted, this is a city of Cincinnati case, but the county prosecutor's office, the Hamilton County prosecutor's office, in dealing with negotiated wet reckless pleas, also makes you plead guilty to the underlying traffic offense, so that you then have two traffic offenses on the record, which makes this inapplicable because it says one and only one of the convictions is a traffic violation. For example, another situation.
But isn't the argument premised on that this would be the only statutes that govern if there was one conviction?
I'm
or
sorry.
one charge?
If there were one charge, a speeding ticket, a traffic light violation, that is not eligible to be expunged.
Right, there has to be multiple charges.
There has to be multiple charges, and only one of the charges can be a traffic conviction, and they all have to come out of the same incident. So, you know, the scenario.
Did you find any case law? I don't recall really any cases interpreting this specific section. I know we have dueling interpretations of the plain language, but I wasn't sure if there are any cases out there helping us out at all.
Not that I was able to locate, Your Honor. It seems to be an issue that hasn't been litigated to that point. I think that this court has the first opportunity to address this issue head on. But Your Honor, I think that if I've answered your question, I'm not sure, but there are circumstances where the city would say this is not applicable because of unequal access. But the reality is, when you have a serious offense that is acquitted or dismissed and a traffic conviction that comes out of the same incident, under the normal reading of the statute without this exception, then all of those would be ineligible for expungement or to be sealed. And in this particular situation, because an OVI was reduced down, and that was the only traffic conviction, and there were other charges that were dismissed. In this case, they were both traffic offenses, but they could have been possession of drugs. They could have been a theft offense if they arose out of the same incident. Then they would all be eligible to be sealed. The other argument that the state makes is that it 2953-61B1 provides.
I just want to let you know,
Yes.
Attorney Siri, you have 1 minute left.
Oh, thank you. The state argues that the 2953-61 provides a limited exception for sealing records of non-conviction, but that's not the correct reading of the statute. A2 says traffic convictions are ineligible except as provided in this section. Then it sets out the rule for that exception as it relates to convictions. Nowhere in the statute does it talk about sealing records of non-convictions as it relates to this exception. It talks about the exception of traffic convictions not being able to be sealed. I believe that the trial court was incorrect in its review of this statute or its interpretation, and that Ms. Christian is legally eligible. And as the trial court said in its decision, it wanted to grant this. So this isn't an issue of did the court abuse its discretion. This is an issue of statutory interpretation and whether or not legally Ms. Christian is eligible, and I believe that she is. Thank you.
So if we were to find that she was legally eligible, what would be the disposition of the case? What is your opinion on the disposition?
Well, I think that the trial court, Judge Kissinger, laid out pretty clearly that he wanted to grant this expungement, but couldn't, in his opinion, because of the statutory language. So I believe that in this particular situation, this court could order the record sealed or could remand it back to Judge Kissinger with the determination that she was, in fact, eligible, which, based on his decision, would result in it being sealed.
Thank you.
Thank you, Your Honor.
Good morning, Attorney Vogt.
Good morning, Your Honors. May it please the court, opposing counsel. So the trial court got the application of the law correct with regard to Christian's ineligibility with regard to her reckless operation conviction. So this court should affirm that portion of the judgment. Sounds like we're all on the same page that a conviction under the city municipal code 506-6 is a substantially equivalent municipal ordinance to reckless operation under the state code 451120. So that kicks in 2953-61A, which basically says that when there are multiple charges that occur from the same act, a person can't have those a record of those charges sealed until all of the charges would be eligible. And
well, can I pick your brain on B1? So I just want to walk through this to make sure I understand the state's position. So the first clause is when a person is charged with 2 or more offenses as a result of or in connection with the same act. And the final disposition of one and only one of the charges is a conviction under, all these sections. So would you agree with me that up to that point, that is satisfied in this case?
yes.
Okay. So then the question becomes, that the court may order that the records pertain to all charges be sealed. And I think, as I understand your position, you're saying that all charges does not include the charge that results in the conviction. Is that right?
Yes, Judge, that's correct.
Okay, so can you help me understand that from a plain language meaning of this statute?
Yes, Your Honor. I think the where that is and what that makes sense is the immediately preceding clause in that statute, which says that, and if the records pertaining to all the charges that would otherwise be eligible for sealing under 2953-52, in the absence of that conviction, that's all the charges to which the court may order the records pertaining to all the charges that would be otherwise eligible under 2953-52, which is, of course, the dismissals sealing statute. So I just think I see where Mr. Suri's coming from. It does say all the charges, but because the immediately preceding clause says all the charges that would be eligible, all the otherwise eligible dismissal.
Well, it says all the other charges. So there's like there's an all of the other charges, and then there's all charges. And so I think his reading is all the other charges means the ones that there was no conviction on, whereas all charges is broader than that.
Yes, I mean, I understand where he's coming from. I think that's the plain language that supports our position, and I think this kind of gets into the second part of my argument about the unequal access portion, where obviously a court has to read statutes in a way that provides a logical result, and then under Mr. Suri's position, a person would need to have associated non-dismissals or non-convictions for a conviction under 45.
Isn't your argument premised on that there's no other statutory section that applies if there's only one charge? This is obviously a statutory section that applies when there's multiple charges. So isn't it premised on that there's no other statute out there that applies when there's one charge?
Yes, Your Honor. I think that's accurate. And then just, I think that falls back on 2953-36, which outlines the various convictions that are ineligible to have records sealed. So if a person only has one conviction under the list of those ineligible offenses, they wouldn't be able to avail themselves of 2953-61B1 unless they had additional non-convictions, which would, I think, be an illogical result.
Well, yeah, I mean, look, there's a lot that this statute begs in terms of questions. Like, I don't understand why the legislature decided to structure it this way. But they did create this kind of unusual exception that allows someone who's facing multiple charges but only convicted on one this opportunity, if we agree with Mr. Suri's argument. And I guess, like, what if that were the case, then why is that problematic?
Well, yeah, I agree with you, Your Honor, that there are seemingly exceptions within exceptions
Yeah, you need a map to navigate the revised code on all this.
I don't disagree with that, Your Honor, but I think, 29, just to go back to A, if you'll permit for just a second, under that section, a person, if they have convicted under something under 2953-36, like a reckless operation, they're ineligible to have associated non-convictions sealed from their record. And I think, simply put, B1 just offers an exception to the normal rule of 61A that would otherwise preclude people from having non-convictions sealed from their record. And I think the language, especially since it references in B1 the, again, offenses that would be non-convictions that would be eligible under 2953-52, I think the intent is clear there. And I know you do need a roadmap, but the roadmap is unambiguous from our position that it does just provide a limited exception to 2953-61A's plain language rule. And for our purposes as well, the Supreme Court has already found this statute to be unambiguous in State versus Priag in paragraph 22. So I think I agree it is unambiguous, although a bit complicated. Just because it's complicated doesn't mean there's an ambiguity here.
But did they interpret any of these issues in that case?
Priag was mainly about A, Your Honor, and I agree with Mr. Suri that in my review of B1 specifically, the jurisprudence for this specific subsection does seem limited. I don't believe it's cited in my brief, but there is a case out of the 8th District, State versus GK, and the web citation for that is 2020 Ohio 5083. That does go into a little bit about why sealing of non-dismissals, partial sealing at least of non-dismissals is permissible. So just to reiterate, the plain language creates an exception to A's rule. I think that's logical. And then again, the unequal access portion of our argument, I think, speaks for itself. So, with regard to this portion of Mr. Suri's argument, we would ask the court to hold that because 506-6 convictions under the municipal code are substantially similar, they're plainly ineligible, and that 61B 1 just only provides a limited exception to 61A's rule that associated non-convictions to an otherwise ineligible conviction, just wouldn't be eligible otherwise. So unless there are any other questions about that, as the court did see in my brief, we do partially concede. The language in B1 with about 451119 or 194, so OVI and physical control convictions, I think that's just an exception within an exception. Again, we'll have to add that to the roadmap, why this B1 wouldn't apply. So if a person has been convicted of an OVI, then they can't have associated non-convictions expunged from their record. And just to distinguish briefly Mr. Suri's hypothetical, I think he talked about if a person was convicted under a traffic light violation and they were not convicted of an OVI, that it's our position that they wouldn't be eligible. And I mean, we're conceding that the trial court erred with regard as a matter of law as to why Ms. Kristen wasn't able to have the record of her non-conviction dismissed OVI expunged from her record. I think they slightly got that reason wrong. We just maintain that we have an interest in maintaining the record of that non-conviction as discussed in our brief. So unless there are any other questions, we ask this court affirm the trial court with regard to Ms. Kristen's ineligibility to have the record of her reckless operation conviction sealed, and just concede in part and remand it for analysis about the state's interest versus hers.
Thank you.
Thank you.
Attorney Suri, so you have your 4 minutes.
Just briefly, Your Honors, I think, again, it's worth reiterating that the application of this is geared towards the expungement or sealing of records of conviction, not affiliated non-convictions. And that's clear from the plain language. If you look at 2953-36A2, it says convictions under the Cincinnati Municipal Code dealing with traffic violations are not eligible for expungement, except as otherwise provided in section 295361. So it's specifically telling us that convictions are not eligible to be sealed, except as provided in 295361. Looking at B1, as Your Honor had previously, when a person's charged with 2 or more offenses and only one of them is a conviction under the reckless operation statute in this case, and if the records pertaining to the other charges, talking about the dismissed charges, then the court may order that the records pertaining to all the charges be sealed. So to try and stretch this into, you can seal records of non-conviction when there's a otherwise ineligible conviction, just flies in the face of the plain reading of the statute. And I think it also is important to look at that very last sentence of B1. It says, in such a case, the court shall not order that only a portion of the records be sealed. So in other words, from a practical standpoint, it's impossible to do that. So if you have a citation with multiple charges on it, are the police department supposed to then go back and redact only a portion of that? What if you have a police report that talks about the incident? Are they going to go back and redact the individual portion? It's just, as a practical matter, not possible. So in this particular situation, it's an all or none type scenario. Because there was one and only one traffic conviction, the 2 dismissed charges are eligible to be sealed under 295352 as dismissals of misdemeanors. Then if the court is inclined to do so, he is able to order the sealing of all the charges, which would include the conviction as well as the dismissals. And for that reason, I would ask the court to reverse the trial court decision.
Thank you. It was great seeing both of you this morning. Thank you both for your arguments. We will take the matter under submission and issue a timely decision. And we wish you a wonderful afternoon.